All right, good morning, everyone. My name is Diane Sykes. I am a judge on the Court of Appeals for the Seventh Circuit in Chicago. It's my pleasure to be with you here this morning to moderate this panel discussion on the topic of originalism and construction. Does originalism always provide the answer? One of the more interesting and important developments in new originalism addresses the role of constitutional construction in deciding constitutional cases. This development follows naturally from the evolution of modern originalist theory, from old originalism's focus on fidelity to the framer's intent to new originalism's commitment to the original public meaning of the constitutional text. Any theory that centers on meaning requires a set of principles for resolving questions of textual and contextual ambiguity and vagueness in particular applications. And even where the original meaning is reasonably discernible, it might not be enough to decide individual cases. As scholars across the philosophical spectrum have explored theories for determining and applying the original public meaning of the Constitution, the distinction between interpretation and construction has emerged as a prominent feature of new originalist thought. As we shall see, the distinction sometimes travels under other names, and the various iterations of it have subtle and sometimes not so subtle differences. Scholars also disagree about where the line should be drawn and what norms ought to inform the judiciary's approach to each step in this method of constitutional decision-making. The debate implicates essential foundational questions of the proper sources of constitutional authority, the requirements of constitutional fidelity, and the appropriate uses of the power of judicial review. This symposium has assembled a very distinguished panel of experts to explain the concept of constitutional construction, to discuss its theoretical justifications, and to debate the extent to which it ought to influence judicial decision-making in constitutional cases. To my immediate right, also your right, Professor Randy Barnett is the Carmack Waterhouse Professor of Legal Theory at Georgetown Law Center. Well known to members of the Federalist Society, he is a prolific writer and teacher on all manner of issues in constitutional law, contract theory, jurisprudence, and legal theory. But he is perhaps best known for two particular endeavors. He was the lawyer who argued Gonzalez versus Raich, the Supreme Court case on the issue of the congressional power to regulate medical marijuana, and he is the author of Restoring the Lost Constitution, the Presumption of Liberty, which I commend to you. Before entering the Legal Academy, Professor Barnett was a prosecutor in the Cook County State's Attorney's Office in Chicago. He received his bachelor's degree from Northwestern University and his JD from Harvard. Seated next to him, Professor Caleb Nelson is the Emerson G. Spees Distinguished Professor of Law at the University of Virginia Law School, where he teaches constitutional law, civil procedure, legislation, and federal courts. He, too, has written widely on constitutional law and legal interpretation and is currently working on a casebook on statutory interpretation. Before joining the law faculty at UVA, Professor Nelson practiced appellate litigation in Cincinnati and was a law clerk to Judge Stephen Williams of the United States Court of Appeals for the D.C. Circuit and Justice Clarence Thomas of the United States Supreme Court, and his JD from Yale Law School. Next in line, Professor Kermit Roosevelt is well known to you here at Penn Law School as a professor of constitutional law and conflicts of law. His work frequently appears in law reviews and scholarly journals, on the op-ed pages of leading newspapers, in book chapters, and on the fiction shelves of your local bookstore. I don't mean to suggest that his legal scholarship appears on the fiction shelves. Professor Roosevelt is a published novelist. Before coming to Penn, he worked in appellate litigation at Mayer Brown and Platt and clerked for Judge Stephen Williams of the United States Court of Appeals for the D.C. Circuit and for Justice David Souter of the United States Supreme Court. He received his bachelor's degree from Harvard and his JD from Yale. Next in line, Professor Lino Graglia is the A. Dalton Cross Professor of Law at the University of Texas School of Law. He is the Legal Academy's contrarian-in-chief. He is widely published in constitutional law, especially on the topics of judicial review, constitutional interpretation, race discrimination, and affirmative action. He is also an expert in antitrust law. Before joining the law faculty at the University of Texas, Professor Graglia was an attorney in the Department of Justice and practiced law in New York and Washington, D.C. Professor Graglia received his bachelor's degree from the City College of New York and an LLB from Columbia. And finally, the Honorable A. Raymond Randolph is Penn Law School's gift to the federal judiciary. He was appointed to the United States Court of Appeals for the D.C. Circuit by President George H.W. Bush and confirmed by the Senate in 1990. He began his legal career as a law clerk to Judge Henry Friendly of the United States Court of Appeals for the Second Circuit and proceeded from there to several important positions in the government, including Assistant to the Solicitor General, Deputy Solicitor General, and Special Counsel to the Ethics Committee of the United States House of Representatives. While in private practice in Washington, Judge Randolph served as Special Assistant Attorney General for the states of Utah, New Mexico, and Montana. He argued 23 cases before the United States Supreme Court and has taught as an adjunct professor of law at Georgetown and George Mason. Judge Randolph received his bachelor's degree from Drexel University and his JD from the University of Pennsylvania. With that, we'll start with Professor Barnett.